So by way of background, I'm an attorney with my own law firm. I practice in the areas of estate planning, probate, trust administration, employment law, and civil litigation. Graduate of Punahou School, was born and raised in Honolulu, Hawaii, graduated with my bachelor's, and then went on to get my Juris Doctor degree from the UCLA School of Law. I'm currently an instructor at Kapilani Community College in their legal education program, as well as a lecturer in law at the University of Hawaii Richardson School of Law. I was also formerly a partner at the Goodsill law firm, and we're very excited to be here today. So now I'll let Nohea Lani introduce herself.
Hi, I'm Nohea. I'm also a Punahou grad. I'm currently in my last semester at American University studying international studies and entrepreneurship, and I'm super excited to be here today.
Okay, thank you. And then Yasmin.
Hi, everyone. My name is Yasmin. I am a current student of the Legal Studies program at KCC and a paralegal intern in the Pro Bono Clinic, and I'm originally from Brooklyn, New York.
All right, so thank you. So just a few housekeeping things I want to take care of. So because I'm an attorney giving a legal presentation, I wanted to just put this out here, this legal disclaimer. So the information contained in this presentation related to the materials are not intended to constitute legal advice or any kind of rendering of consulting or other professional services, and it does not create a contract for legal advice. So I just wanted to make that clear while we proceed with our presentation today. Okay, so as far as the agenda for today, we're going to be talking about what an estate plan is, as well as who needs an estate plan, the importance of it, provide a brief summary of some of the common estate planning documents, and then we're also going to share about our estate planning clinic, and then at the end we should have more than enough time for any questions that any of you folks might have, and so we can answer those at that time. But now let me turn it over to Yasmin, who will be talking about what is estate planning.
So what is estate planning? Estate planning is a process of creating a plan for a client's assets. Everyone has an estate. An estate is everything a client owns upon death. That includes a house, real property, car, jewelry, furniture, stocks, cash, etc.
And we'll be addressing these documents separately later, but some common estate planning documents include a trust, will, power of attorney, advanced healthcare directive. And when preparing your estate plan, it's important to have a good team of people to help throughout the process. They may include an estate planning attorney, financial advisor, accountant, and an investment advisor. And the objectives of estate planning include ensuring there is an effective and efficient transfer of assets upon your death or incapacity. Other objectives include fulfilling your property transfer wishes, minimize transfer taxes and costs, maximize assets to beneficiaries, provide liquidity at death, plan for your children, and lastly, fulfill healthcare goals.
So why is it important to have an estate plan? Well, there's several reasons, and they include you will want to plan for your incapacity, ensure your privacy, and avoid probate, which is a concept that we will discuss in a future slide. You also want to ensure that you dispose of property pursuant to your wishes. And then you also want to maximize any estate and transfer tax exemptions. So estate planning will help you achieve all of these goals. So it's important to get your estate plan done. And so some of the terms that I wanted to discuss include the terms testate and intestate. And so some of you may be familiar with these terms, but basically when you die, testate means that you die with a will or a trust, and the property can be distributed pursuant to your wishes. Now, if you die intestate, it means you die without a will or without a trust. And the domiciliary state intestacy laws will control. And so domiciliary state is a state in which you pass away. And so if you're a Hawaii resident, then the Hawaii state intestacy laws will control. And I guess what a lot of people don't realize is that if you die without a will or trust, your property does not automatically go to the state. It's distributed pursuant to state statute, which usually means your heirs at law. So in Hawaii, we have a Hawaii intestacy statute, and it basically dictates what happens to your property. And so usually, depending on if you have your parents alive, but usually it goes to your descendants, which means like your children, and then it would go back up. And so there's just a statutory statutory law that basically says where your property goes after you pass away in the event you don't have a will or a trust. Now, who will inherit your estate depends on how your title to your assets is held and whether a valid trust or will exists. And so one of the first things that we look at, or that I teach my students in my courses, is, we look at property and then how they're owned. And so is your property owned jointly? Is it owned individually? Are there beneficiary designations? So for example, if you have a life insurance policy, do you have a beneficiary designated, or is it held in trust? And so by way of example, if you own property together with someone else and that's held as joint tenants, then when one person dies, it automatically goes to the other person. However, if you do your estate plan and this is how you own your property, let's say husband, wife, and you create a trust, the property doesn't automatically get placed into the trust. You're going to have to retitle the assets into the name of the trust. So from this joint tenancy, then you're going to have to put it into the trust. Same thing with beneficiary designations. Just because you create a trust or an estate plan doesn't mean that you're automatically going to have your trust designated as a beneficiary. You would have to contact your life insurance company. And so our firm, or actually our clinic, we help clients prepare, their will. My firm helps people draft trusts, and then we help transfer property, that's held jointly in, or even in someone's individual name, into their trust. And so it's really important. And so even if you create a trust, you do not retitle your assets in the name of the trust, it will not be disposed pursuant to the terms of the trust. So funding your trust is really important. Okay, so some basic estate planning documents. So typically in a trust or estate planning package, we prepare a trust, a will or a pour over will, power of attorney, advanced healthcare directive, assignment of tangible personal property, a deed, and something called a post document. Today, we're going to just be talking about the basics because we only have an hour. I'm going to talk about some of the most common documents. And so that's the trust, will, power of attorney, and advanced healthcare directive. Now, one of the misconceptions that a lot of people have is that they don't think they need an estate plan because they don't have much in assets. But this is not true, because everyone needs an estate plan. But then the question that you want to ask yourself is, do I need a trust or do I just need a will? Right? So, and the answer is, it depends. It depends on what you own. And so, do you own real property? Do you have assets in excess of $100,000? Because what you're really doing for a trust is you're planning for incapacity. You're also planning for what happens after I pass away. If you want privacy and you want to manage your assets without having court involvement, then you would want to do a trust. Some people would just say, you know what, I just have a checking account. I don't have to go through the probate process anyway. So I just need a will. I just need something simple. And so, it just really depends. So we're going to talk about both the trust and the will. And so a trust is a revocable and amendable document that vests legal title to assets in the trustee. And so the party that manages the assets is the trustee, and then the people who benefit from it are the beneficiaries. And so with revocable living trusts, those are the most common. which means that you would take your property, you would put it into your trust. You as a settlor are also the trustee, so you're managing everything during your lifetime. Only in the event you become incapacitated will the trustee, your successor trustee, step in, and only upon your passing, unless you indicate otherwise, will your beneficiaries receive anything. So you're not giving anything away if you're creating a trust. You're just creating a mechanism. So it's kind of like a just in case something happens, then the trustee will step in, and then the beneficiaries will get it upon your death or whenever you choose. Trusts, again, are amendable and revocable. So which means that unless you create an irrevocable trust, most trusts that that we would recommend would be you can amend it during your lifetime, you can revoke it, you can make changes. It provides flexibility and privacy. And so when I say privacy, it avoids the probate process. And so the probate process, it's a legal process through which a decedent's assets are distributed to heirs. And so again, if you die with real property and it's in your individual name, you might hear something called the probate process, like, oh no, probate, everyone dreads probate, but it's during this process, a personal representative is appointed, they collect assets and distribute assets to the heirs. And this is a document that's filed with the court. So it's a public document. Where all the heirs at law are, sent a copy of the will, all of the documents. I guess it's a little more expensive on the back end. You have to go to court, or you have to file documents with the court. In Hawaii, fortunately, we have something called the informal probate process. And so it's not as cumbersome as the formal probate process. And it doesn't require a court oversight, but nonetheless, it's still a public process. So people try to avoid probate by creating a trust. And so, going back to the trust, some of the major provisions include appointment of a successor trustee, the disposition of assets, as well as holdback provisions, which means that if a beneficiary is not a certain age, at the time of the settlor's death, the trust asset is held in trust in this holdback trust for the beneficiary until they reach a certain age. And so a lot of clients will ask, well, what's the reasonable age? And so the most common one I see is 25. Some people say 30, 35. I had one client who said 50. Sometimes people say for the person's lifetime. But again, the idea behind the 25 is they feel like, well, the person is, an adult, they're gonna not spend the money foolishly. They're already done with college, theoretically, they're already done with grad school. And so, they can get the money outright at 25. Okay? But it really just depends on individual preference. Now, we talked about a trust. Another document that people use the word will and trust interchangeably, but they're actually two different things. Okay, so when we talk about a will is a legal document that gives the testator or the will maker the opportunity to control the distribution of her property at death. It can be amended or revoked during lifetime, and then the provisions are not effective until death. And so some of the major provisions of a will include the appointment of a personal representative. Some places they call it an executor. If you have minor children, the will also provides the appointment of a guardian for minor children. It has a provision about payment of taxes, debts, and expenses. Sometimes funeral wishes are included in a will, as well as disposition of assets. And so, if you do not have real property and your assets are less than $100,000, a simple will may be the right document for you. And there is no need for a trust. And so that's what we do for our pro bono clients, is we do simple wills. However, even if you have a trust, attorneys typically prepare something called a pour over will. So if you did have real property and you wanted a trust, we would still create something called this pour over will. And that basically is a will that directs that any assets in your individual name go to your trust. So it accompanies a revocable trust. And for the pour over will, ideally, you won't have to use the pour over will, because if everything was titled properly in your trust would control everything. But to the extent that, let's say, after you create your trust, you have, I don't know, you buy investment property and you forget to title it into the name of your trust and it's in your individual name and you pass away, then the pour over will would basically transfer that property. It would direct that that property be transferred into your trust. And so one thing that you want to remember is that even if you have a will, depending on the type of asset, so again, if you have real property or if you have assets in excess of $100,000, then you would still need to go through the probate process. You don't have to go through the probate process if you have a revocable trust, but if you just have a will, you still would have to go through the probate process if you own real property. And so, that's something that, people, aren't, I guess it's just a common misconception. So just be aware of that. And then now these last two documents here are the durable power of attorney and advanced healthcare directive. And the reason why I grouped them together is because these documents are both only valid during your lifetime. So once you pass away, these documents are no longer valid. And so when we talk about a durable power of attorney, this document provides a person with the ability to name an agent to handle their financial decisions. So you can either make your durable power of attorney effective immediately upon signing, or in the event they become, you become incapacitated. So we call that the evergreen and the springing. So we can put provisions in there to say that this person has ability to make financial decisions on my behalf, like immediately, or only when I become incapacitated. And then just so you know, banks, they typically require you to update it like every 5 years, or they might even have their own form. And so I know clients will say like, what, my form, the bank's not taking it anymore. And it's because it's more than 5 years old. So that's why the standard is, people should update their estate planning documents about every 5 years or so. Or if there's life-changing events, like if you have like a birth in your family or a death or, something. So you should just have someone review it. Now, an advanced healthcare directive is a document that provides individuals with the ability to appoint an agent. So an agent for healthcare decisions. And in the document, individuals can also make end-of-life decisions as well. And so the end-of-life decisions is usually a check the box form of, do you want to be kept on life support and life sustaining machines to prolong your life, or do you want rather just not have that? And so, but many people, they don't realize the importance of, especially an advanced healthcare directive and making their end of life decisions known. So some of you may be familiar with the Terry Schiavo case, where Terry Schiavo was a young woman. She suffered cardiac arrest and then eventually was in a vegetative state and on life support. And it was life-sustaining treatments. And her husband and parents engaged in a legal battle to determine whether to keep her on life support or to take her off life support. And she did not have an advanced healthcare directive. So this was a very lengthy legal battle, very highly publicized. I guess the issue was, the parents were religious and said that, she wouldn't have wanted to not be kept alive. And then the husband said, no, but this was not her wishes. And so, it went all the way up to the Supreme Court. And then, so what I wanted to do is show you folks a quick video. See me, and this is a Terry Schiavo case. So it's just a quick video clip. It's about 2 minutes, just kind of documenting the legal battle and the struggles that the family faced. Okay. So that is just to demonstrate what can happen if you don't have an advanced healthcare directive. And as you may be aware, there's also other famous probate cases. And so in one of my classes, I have my students present on different famous probate cases just to drive home the idea that it's important to have a good estate plan in place. And so here are just some examples. Aretha Franklin, we have Michael Jackson and Prince. So Prince and Aretha Franklin apparently died without a will or a trust. And so I know a lot of the media, they talk about, oh, they didn't have a will, but even if they did have a will, they would still have to go through the probate process because these people had tons of money. And so really the technical term is they would have needed a trust, but they had neither. And so they had to go through the probate process and then let the state intestacy laws control. And so if they had like friends or people that they wanted to leave some of their assets to, they weren't able to do so because the statute doesn't provide for them to, give their assets to friends. And then Michael Jackson, he had a will and a trust, but apparently his trust wasn't properly funded. And so again, if your trust is not properly funded, right, and you have the amount of assets that he has, he had a pour over will. And so if it's in his individual name and not properly titled in the name of the trust, the will would direct that the assets would have to go into the trust. But in order to do so, he would have to go through the probate process as well. And so that's another reason why, good estate planning, is important. Okay. And so again, so as I mentioned earlier, in addition to practicing law, I'm an instructor at Kapiolani Community College's paralegal program. And we started the estate planning clinic basically to provide free legal services to the community who can't afford them. But at the same time, I have volunteer students and they're the ones who assist the clients, and they, under my supervision, but they get the actual real world experience. And so we're providing free legal services for people who do not own any real property or have assets less than $100,000, because then they would just need a simple will, advance healthcare directive, and durable power of attorney. So that's one of the services that we provide at no charge. So we don't charge for any of our time. And we do it all virtually. And so this year we had a virtual estate planning clinic. Normally it's in person, but due to the pandemic, we decided to do it virtually. And I had 9 student volunteers volunteer at a time. So you can see Yasmin and Nohea. So they're pictured in the photos. And they all had an opportunity, and you'll hear from both of them about their experiences, about their experiences in the clinic. And then we, in addition to just taking clients, from the public, we partnered with the Volunteer Legal Services of Hawaii, and we drafted over 100 documents for the community. So it was all pro bono legal work that we did. So we did wills, advanced healthcare directives, powers of attorney, and especially during COVID, I had a ton of requests just because people were wanting to plan. And a lot of them came from the nursing facilities around the island. And so one of the things I like to stress is that, in the clinic, I used to work at a downtown law firm, and I just wanted the students and the clients to get that downtown law firm experience because, just because we're providing pro bono legal work doesn't mean that, we shouldn't be professional, or that people should not get the quality of legal work that they would had they been able to afford it. And so what I did for the students is we had them, created business cards for all of them, with the law firm logo. And the reason why it's my law firm is because in the beginning, when we tried to, partner with other organizations, we didn't have anyone to partner with. And so, I ran it under my law firm, got the malpractice insurance. I bought them all pad folios, as well as, client folders, just so that, the clients would get the full experience. And so I partially funded it initially. I'm still partially funding it. However, we received a grant from the Hawaii Justice Foundation as well. And so we're really fortunate to receive that grant to continue our program, just so that we can continue to provide this service without compromising on the professional look and feel of the whole program. And so here's a video that we created, and it documents the students' experiences from my prior clinic, And then again, you'll hear from Nohea and Yasmin about their experiences in the clinic, but this video will just, where you can learn more about the clinic. So let me play the video. Let me change the volume.
I really wanted to be a part of this clinic because I felt like it would be a great opportunity for me to learn to work with clients, meet with them, and overall how to be a paralegal. I would highly recommend to any student who's interested in the legal field to join this clinic, not only because it's very hands-on and you learn a lot, but also because Professor Kim goes above and beyond to make sure that you're comfortable, confident, and knowledgeable when it comes time to meeting your clients.
In the clinic, I was able to gain experience drafting documents, I gained experience interviewing with clients, and overall, I'm really grateful for this opportunity, and I recognize that people went out of their way to make this happen, especially Professor Kim Koide. So I'm really grateful for this. It benefits us paralegal students, and I strongly recommend other students to volunteer as well. So thanks again for making this happen, and I'm so happy to be one of the first few people to participate.
All right. So, okay. So now I'd like to have Nohea and Yasmin maybe share a little bit about their experiences since they're here and they participated in the clinic. So we'll start with Nohea.
Sure, yeah. So as an undergraduate student, and especially in Hawaii, I recognize it's super rare to find opportunities that give like real life experience in the law and estate planning area. And so I feel very fortunate to have joined this clinic. And my favorite part of it is asking each client's like unique needs and helping them as best as I could. And I was able to do that through like client interviews and drafting their planning documents to their specific needs. So I'm super grateful and happy I joined.
Thanks, Nohea. Yasmin?
Yeah, my experience in the legal clinic has been amazing. I worked on a team that drafted estate planning documents for a married couple, as well as had the opportunity to work with an unmarried individual in drafting the estate planning documents. And doing that provided me the opportunity to see the differences that may occur across the needs of different clients. And as a current student in the paralegal program at KCC and an intern in the legal clinic, I was able to see how my education was applied in a real world setting. And I had no history of working with clients in a legal setting prior to joining the legal clinic. And having that education as well as the support of Kim made it a very positive experience for me. And it was not nerve-wracking at all. It was really, really positive.
All right, well, thank you. So these paralegal interns, so Nohea and Yasmin, I mean, they worked very, very hard, for the clients. Glad that they got, the experience, and I know that the clients really appreciated it because they thanked me over and over again, for providing the service. And so, we wouldn't be able to do it without the students, obviously. So, so if anyone's interested, again, it's a will, advanced healthcare directive, power of attorney. Feel free to email. And as far as questions, so at this time, we're at the end of our formal presentation, but I'm happy to take any questions. But first, I'd like to address this question we have right here that someone submitted ahead of time. And so maybe Nohea can read the question.
Sure. So the question is, I would like to know what happens when a property is left to more than one person in the family, for example, 3 adult siblings. What happens if one wants to sell it and another wants to hold it onto it? Can the person who wants to sell the property force the other to sell? Um, this is assuming that they all cannot agree on a buyout amount.
Okay, so the answer would be it depends. And so if the property is held in trust and the trust says to distribute the property to the 3 individuals, then the trustee should distribute the property and the siblings will need to determine what to do with the property outside of the trust. So again, if the parties can't agree, then they would have to go through something called a partition action, which is a court proceeding to force a sale. If the property is to be held in trust, of which the 3 siblings are beneficiaries and they cannot agree what to do, then the trustee can then file a petition for instructions with the court, and then the court may order that the parties work out an arrangement, or they may order that the property be subject to a partition action. So it really just depends on what the trust says, whether the property is, if the trust says property goes to the 3 siblings, just distribute it outright, the 3 of them own it, and then then they can't decide what happens, right? Like, whether do we keep it, do we sell it, and then let's say one wants to sell, the other ones don't, or vice versa, then someone would have to initiate a partition action in court. But it really just depends on the terms of the trust. And again, if it's kept in the trust itself, then if it's supposed to be held in trust and then someone wants to sell it, then the trustee is going to have to make the decision. Then they would usually go to court for instructions. Okay. I don't know if the person who asked that question is on and whether that answers it. I know that I think Debbie and others are, I'm trying to get to my, here. See if there's any questions. I'm going to open it up now to any other, any other questions that you folks might have. Let's see, sorry, let me.
On the panel, there is a Q&A box. So if anybody has any questions, feel free to type it in there so Kimberly can go ahead and answer the questions.
Yeah, so if anyone has any questions, I'm happy to answer it at this time. I'm gonna make sure I monitor it.
So no,
if you're interested in, oh yeah, go ahead, yes.
Oh, no. So there's, I was just saying that there is no questions. Oh, actually, sorry, one just came through. Does that mean that any one of the 3 beneficiaries can contest the trust?
As a general matter, yes, anyone can contest a trust. You would have to have a reasonable basis though. So you wouldn't contest the trust, on the basis that I disagree with what the trust says necessarily. It would be more so along the lines of, well, I think the trust is invalid because the undue influence was exerted over the settlor. When the settlor drafted the trust or signed the trust, they lacked the requisite capacity. So I don't think this trust amendment is valid. But as far as, so that's generally beneficiaries can contest, but on those bases, if let's say in this particular instance with the partition action, that would be depending again, if the trust says that the property should be held in the trust, or if the trust says that the property should just be distributed. If it's just distributed and the parties can't agree, then again, you would be probably facing a partition action. Okay.
Thank you for that. If there's any other questions, feel free to type it in. And if not, you can always send me an email with your questions and I can forward it to Kimberly to answer as well.
Okay, power of attorney. So it says, what happens after the individual passes and there are legal financial decisions to make? Can a power of attorney be created so that the designated agent can continue to address? No. So for a power of attorney, it's only valid during your lifetime. so the person's lifetime. So if the person is incapacitated, then you would use a power of attorney. And so, okay, and so then to address the legal and financial tasks, so you would probably want to have a trust set up for the person, assuming they have real property or a lot of assets. If not, a will would be sufficient, because we have something called an affidavit of collection. So if you have assets under $100,000, then you could use the affidavit of collection. You avoid probate. You could still manage all of the person's legal finances, legal issues and financial issues through a will. And so again, a will and a trust is needed after someone passes away to manage their financial decisions. A power of attorney is only valid during the person's lifetime. Okay, so next question is, if upon death, other assets are discovered, life insurance that has other beneficiaries that are no longer appropriate, and it wasn't in the will. Okay, so that's an excellent question. And so unfortunately, if let's say someone updates their estate plan, but they forget to update the life insurance policies, then unfortunately the life insurance policy beneficiaries are going to be the recipients of whatever life insurance. So I mean, I see that happen a lot where, someone has someone named, but let's say they cut them out of the will or trust, but then they forget to change their beneficiary designation. So that's why it's important to have a good estate planning attorney who's, going to properly advise. So what I usually tell my clients is that if you're updating your estate planning documents, you also want to update your beneficiaries of your life insurance policies or your beneficiaries of your 401k. Okay. Okay, so as a volunteer in Navien, what role might I play in a patient's behalf regarding estates? Okay, so I mean, as a volunteer, I'm assuming you're a volunteer caregiver. So, I mean, what you could do is you could just say that, do you have, I mean, if it comes up, right? Do you have an advanced healthcare directive? Do you have, like, who's going to take care of your finances? Do you have everything set up? It's not something that is easy to talk about necessarily, but then, I know that financial advisors are often in that situation, caregivers. And so, I mean, the most you can do is, I suppose, ask them, do you have your estate planning done? Or do you have an advanced healthcare directive? And if you don't, then, here are some resources where you need to look into this. And that's assuming the person has capacity. If the person doesn't have capacity, then they're unable to execute their estate planning documents. And so it's important to get the person to do it while they still have the capacity to do it. So that's a great question. Okay. Any other questions?
Kimberly, I actually had a question. I know you didn't have a chance to go over the post. Could you go over the difference between having an advanced care health directive and the post?
Okay, so the post document is, it's printed out on a green piece of paper. Let me see if I can grab a copy. I actually have one, but it's the physician order life-sustaining treatment document. And so basically an advanced healthcare directive is a directive to the physician, letting the physician know that, it's letting people know that this is my wishes as far as my end of life decision. So if I'm in the hospital, then the doctors would take direction from the advanced healthcare directive. However, the post document is more for first responders. And so the document is not filled out through me. It's a standard form in Hawaii. And you would fill it out with your physician. And then you would theoretically post it up in your house. And so that if first responders come, they would know that do not resuscitate me, or do not perform CPR, do not perform life-sustaining treatments on me. Otherwise, they're bound to do so. And so some of my clients in the past have said, oh yeah, the advanced healthcare directive doesn't work. And so that's the reason why, we include the post document as part of the estate plan. It's not something that I draft. It's just a form that we have that we download from the state of Hawaii website, and then we give that to clients and tell them to fill it out with their physicians. And so you know, they can post that up in their house so that when the first responders come, they can just point to the post. Because I mean, you know, if an emergency comes, it's not like you're going to have time to go reach out into your folder and say, oh, I need to look for the post document, right? You're worried about other things. So we tell clients to post that on their wall and then just point to it when the first responders come. Otherwise, your advanced healthcare directive would be the one that doctors take direction from if you're in the hospital.
Thanks. We have about 14 minutes left. So we still have time for some questions if anybody else has anything. We'll probably give another, I guess, 30 seconds to a minute. We'll see if anything comes in.
Yeah, and you know, I'm happy to answer any questions. If anyone's interested in getting their estate plan done through our clinic, it's completely free. You know, the will, advanced healthcare directive, power of attorney. So if you fall into those categories, or if you know of someone who falls into that category, we have a team of 9 paralegal students and all under my supervision. And so if anyone needs that service, we're happy to provide that. And it also comes with the post document as well. They get a nice binder or folder with all of the documents. And so, you know, we're happy to provide that service.
Okay, well, I think that's, oh, right here. Oh, this talk would be good to have in written form for future review.
Okay, sure.
This webinar is also recorded, so it will be posted on our website if you want to reference it as well. And with that, oh, when is your next clinic?
Someone asked that. When is our next? Someone's offering. We're offering the service right now, so it's through the end of May, because that's when the students, I guess their class ends or the academic year ends, and so. You know, between now and May, if you know of someone who needs a will, advanced healthcare directive, power of attorney, then, you know, let us know and then we can provide that. The next clinic after that will probably not start until the fall again. So then I have a new cohort of students. I train them up in my probate estate planning class, and then we start taking on clients at that time.